Constitution, the law and the purpose of justice, peace and political stability cannot be put aside simply on the basis of concerns about human rights violations. Nor can the groups attacking the country's defense institutions be considered above justice on the basis of their influence and relations. While it is the responsibility of the government to ensure the environment for the observance of human rights and the provision of justice, the rule of law and the protection of institutions also fall under the responsibility of the government. The military courts have been challenged in the Supreme Court, and the position has been taken that the proceedings in the military courts are not transparent and fears of violations of basic human rights have been expressed. The application has been filed by Aitsaz Ehsan. Aitsaz Ehsan himself has been the soul of the judiciary restoration movement, and even after the restoration of the judiciary, his voice has always been raised for the better reputation of the Supreme Court, and he has also been saddened by the division among the judges of the recent Supreme Court. Now he is going to write a new chapter in the legal history of Pakistan, so he should save it from being controversial, and in this context, he should have requested along with his application that this case should be decided by the full bench of the Supreme Court. Listen so that tomorrow no one can raise legal or moral questions on the decision of this application. The full court was not requested. The manner in which the ethical and legal questions raised on the decisions made by the Supreme Court through the arrangement of administrative powers and the results of the 3-4 and 2-3 ratio opinions affected their implementation. Can the same case be repeated again? My polite request to these honorable lawyers is that this law has been in force since 1952, and in 2015 Section 2 was amended for the trial of terrorists in military courts, and probably at that time Aitsaz Ehsan was not only a member of the Senate but also the leader of the opposition. And the Hussein coincidence is that at that time leader of House Raja Zafrul Haq and Chairman Senate Mian Raza Rabbani, and all of them were lawyers. Was a member of the Senate, this amendment was passed and civilian trials were held before him in these courts. Sardar Latif Khosa was the Central General Secretary of the then opposition party People's Party. Then after that the former Prime Minister, whose cases are now being raised against going to military courts. Even during his regime, cases of ordinary citizens were tried in military courts, punishments were given, but no voice was raised by them in the parliament of that time. So was everything justified at that time, and now suddenly how did they think that all this is against human rights? From these contradictions, the impression of politics of interest in the name of human rights is not emerging to spoil the country's peace and political stability. Is this a matter of turning the page, or is it really about human rights? If human rights are to be raised, then both the bench and the bar should challenge wherever human rights are being violated. Voice should also be raised for the missing persons, and injustice should not be done to anyone. Even those who have committed abuses during their own periods, which their own ministers are admitting, those involved should be punished. Let the matter of human rights remain with human beings, and do not politicize it. Are there no objections and reservations being expressed in the cases that are going on in the civil courts regarding the concerns they expressed about the violations of fundamental rights? The evidence with which the government is challenging the proceedings of the civil courts and the High Court is everything right according to the principles of law and justice. Are not the darkest judgments of this country, which all the lawyers mention every day, from the civil courts was Bhutto hanged by a military court, or prime ministers and politicians disqualified by military courts? Are there not conflicting interpretations of Article 63 of the Constitution, and yet the governments did not implement them both times? Despite the contradictions, there is a limit to any issue, isn't the voice being raised from within the Supreme Court on all these decisions. After all, this situation, are the concerns of human rights violations only on the military courts? The decision of the London High Court 2 days ago on the video of the judge of NAB, in which the said judge is admitting that the decision was taken under pressure from him, evidence for examples of human rights observance by the judiciary of Pakistan. Not enough. Does anyone not hear the resounding testimonies of former Islamabad High Court Judge Kaqet Aziz Siddiqui in the halls of justice? There is someone who should file a petition in the Supreme Court that an inquiry into this matter is also necessary to restore the reputation of the high judiciary. Shouldn't the Supreme Court take some action on this matter, or at least hear their appeal? This issue is not only about human rights, but about the status of those who enforce human rights. Those who cut off their hands for the pleasure of the generals, distorted their identity, massacred the Constitution, even abolished the existence of their own peer courts, today they teach democracy, human rights, and the rule of law. Our giving who doesn't know that all these are the audacity of ignoring from there, otherwise it has been considered honorable to follow the decree issued from there. It is a strange philosophy that military supervision has been considered a source of pride, but military courts are inhuman acts. No one is in favor of military courts and cannot support the punishment of innocent people, but the impression that is emerging from the current situation is that our civil courts should not really uphold basic human rights and punish those involved in these crimes. One can guarantee to meet. According to these dignitaries, these demonstrations were taken there by trapping, so my question is if the top leaders of a political party, retired officers and relatives of judges of the Supreme Court can be lured there. So, the apprehension cannot be denied that in the name of law and justice, even high-level positions are being misled and used against law and justice and the peace and security of Pakistan. Then, if someone says that some people are afraid of military courts because of prompt, transparent and impartial justice which they are not used to, then it also carries weight. Wasn't the Parliament, PTV and law enforcement forces attacked in the same way earlier, and the decisions of the civil courts on them are not known to all? If the courts of terrorism had provided justice on these cases, why would it be the turn to be trapped in the attacks on the cantonments today? Did not the forces there take action against such riots in Britain and America according to their law? I also request them not to associate their good or bad credit with their community by attributing this effort to the lawyers of Pakistan, and if they want to use this stance, then the great legal experts of Pakistan who, if you are opposing their position, have a dialogue with them and first convince them of your position. There is no right to attempt to spread political instability in the name of the rule of law, in the name of the entire community. I request the lawyers' fraternity of Pakistan that if they are concerned about democracy, human rights, and rule of law in Pakistan, then they should file a petition in the Supreme Court with mutual unity, in which the reputation of the Supreme Court will be destroyed. In order to restore it, it is requested to do a collective review against all the controversial decisions made so far, in which all the mistakes of the previous and present judges in the name of their institution should be addressed, and then their future corrections. Therefore, in accordance with the Constitution and law and the principles of justice, formulate the principles by which the way of this in the name of justice will be closed forever. If our civil courts had the reputation of ending terrorism and restoring peace, why would we have made this amendment in 2015, and the power to establish them is subject to the approval of the federal government, which is representative of the people? The representative government of the people feels the need for military courts in a particular situation, then no one should object to it. We need respect for human rights as well as peace and political stability, which is essential for our survival, whether through military courts or criminal courts. The government has also assured to ensure the observance of human rights, and if any violation is observed, it can be challenged in the higher courts, and the right of appeal against these decisions is also reserved. Therefore, I do not think that an attempt should be made to increase the hesitation and create anxiety among the people by prolonging this matter for any length of time. The observance of human rights should be ensured, but the country's peace and political stability should not be damaged on the basis of mere concerns.